Hi, good evening, everyone. We'll get started in a moment. Just to note that I've started the recording already. We'll just wait for our numbers to pick up a little and then we'll get underway. Thank you. Okay, Audrey, I think we can maybe get started. Thank you very much. Lovely. So good evening, everyone. My name is Mary Claire Kennedy, and we're delighted that you have joined us for our first in our webinar series, for the autumn webinar series with the Irish Institute of Pharmacy. The webinar this evening is on the topic of assisted decision making, Capacity Act 2015 and the Decision Support Service. I'm delighted to be joined this evening by Áine Flynn, who's the Director of the Decision Support Service. Just some domestics before we get underway. I'm sure we're all pros at these kind of Zoom sessions now, but just a reminder to mute your microphones if you could. If you do have a question, just post it in the chat box, and if you hover over your screen, you'll see the chat function appears underneath. So in terms of delivery for this evening, our speaker will have some content to deliver, and then we'll pause for questions at the end. As I mentioned, when you joined the session, we are recording this, and the recording will be posted to the website after the event. Just to mention now that I will stop the recording just before we move to the questions part of the webinar. So the content will be up there for you to review if you wish. We will provide a feedback survey at the end, a link to a feedback survey at the end as well. If you're having any difficulties, maybe just leave and rejoin, but we do have Audrey sitting here as well in the background who can assist if you're having any issues also. So then we can move to our speaker, Áine. When you're ready, she will share her slides. Thank you.
Thank you very much. Thanks, Mary Claire, and thanks to all for your attendance this evening. And I'm sure somebody will shout if they aren't moving in the way that they're meant to.
Yeah, I think we've moved on to the second slide there, I think now. Perfect. Yeah, now we're on the first. Thank you. Yeah, lovely.
Thank you all. Yeah, so just to introduce myself, as Mary Claire mentioned, I am Director of the Decision Support Service, which is the new service established under the Assisted Decision Making Capacity Act. And a little further into the presentation, I'll tell you about my statutory role and functions. So the purpose of the webinar is to open up to the key reforms which the Assisted Decision Making Capacity Act introduces, a bit about the functional approach to capacity, the guiding principles, the new support framework under the Act, tools for advanced planning, our functions, as I mentioned, the Decision Support Service, and where we are on the whole pathway to imminent now commencement. I'm a solicitor by background, incidentally, and in this post since 2017. So my job has been to set up the Decision Support Service. I thought it might happen a bit quicker. I'll come to some of the blockers and dependencies that we've encountered. And then obviously moving into that business as usual role imminently with a growing team around me. So the Act is an Act. Sometimes I find it's important to make that point clear. It was fully signed into law almost 7 years ago, right at the end of 2015, and that followed on a really long legislative journey. This is an Act which was a long time in the making and went through several iterations. Along the way, it was at one stage going to be called simply the Mental Capacity Act. You may know that that's what it's called, or legislation like it is called in other jurisdictions, including England and Wales. And my office, the Decision Support Service, was going to be called the Office of Public Guardian, which again would be its broad equivalent in England and Wales and in Scotland and in some other jurisdictions. And as I'll be saying as I go along, I think those name changes were made advisedly. to reflect the key focus and the emphasis which this Act brings to the whole area of the exercise of capacity. So I'm quoting here from part of the Act's long title. It is an Act to provide for the reform of the law relating to persons who require or may require assistance in exercising their decision-making capacity, whether immediately or in the future. So who's it for? We did some demand forecasting, and the Department of Justice back in the day also did theirs. And they identified there could be as many as 200,000 adults living in Ireland who could be amenable to the supports which this Act offers. And you'd be thinking there about adults with intellectual disability, acquired brain injury, forms of dementia, or an enduring mental illness. Now, that isn't to say that people who fall into that cohort necessarily are going to find themselves on the new support framework. Equally, if you think about in the future, here, what the Act is saying is this is an Act for all of us, because at a future time in our lives, any of us could require supports. And that's why the Act also incorporates tools for advanced planning. As I mentioned, this is an Act which applies only to adults, to mean over the age of 18 years, and we aren't yet fully commenced. Commenced is the term which means a piece of legislation becoming operational. It sometimes happens that when an Act introduces lots of real structural reform, it isn't commenced right away. The same was true, for example, of the Mental Health Act. But after another long journey, it looks like we're finally there, with go live planned before the end of this year. In fact, there should be further developments tomorrow in the Shannon, and I'll speak a bit about those. So these are some of the key reforms which the Act introduces. It abolishes the existing wards of court system for adults, and that is continues to be operated at the moment under the Lunacy Regulation Act of 1871. So a Victorian piece of legislation still largely governs how we manage capacity legislation in this country. The Act repeals an even older piece of legislation from the time of George III, I believe, the Marriage of Lunatics Act 1811, which said that if you were a ward of court, you couldn't get married. You just couldn't. That, by way of aside, actually has been commenced, so it's no longer true that wards of court are prohibited from marrying just because they are a ward of court. That came about, in fact, because a young man living in disability services, he has an intellectual disability, was due to get married in the summer of 2019 to his long-term partner, and his wedding was injuncted the day before by the disability service and his family. And an application was commenced to have him made a ward of court. He has been resisting that application. He has stood up a constitutional challenge against the whole wardship framework, and partly in response, the department moved to commence this section, which prohibited him from marrying if he were a ward of court. So that has happened already. All current adult wards of court will transition out of wardship within 3 years of commencement. There are about 2,200 wards of court currently. The biggest single category would be older adults with dementia, and all of them will have their cases reviewed by the wardship court and will exit wardship within that 3-year period. And they don't have to wait to be reached in the queue. As soon as this Act is commenced, any adult ward or somebody on their behalf can look to bring their case before the wardship court, and the wardship court will assess them, consider their needs, and where appropriate may make orders to move them over to the new supports offered under this Act. Or they may simply have their money and their full decision-making autonomy returned to them. The Act puts on a statutory basis a functional assessment of capacity, which I'll say more about on the very next slide. There are new guiding principles, the 3-tier framework for support, which I'll take you through, those tools for advanced planning, and the Act establishes us the decision support service. So looking first then at that assessment of capacity, and Section 3 of the Act says, a person's capacity shall, and shall always means must in an Act, shall be assessed on the basis of ability to understand at the time that a decision is to be made, the nature and consequences of the decision in the context of available choices. So it's a time-specific and issue-specific approach to capacity. What do you need to decide when you need to decide it? If you're familiar with the formula of wardship, this very obviously contrasts with the court's finding when somebody is made a ward of court. When the High Court brings somebody into wardship, they declare them to be a person of unsound mind. And that has been described as a badge or a status approach. It has been acknowledged that this is really a blunt instrument. Often people are taken into wardship on an application by a family member or sometimes by a service, because there's a big decision to be made, perhaps to do with a significant piece of property or a significant healthcare decision, or sometimes where there are broad kind of safeguarding concerns, as this is somebody who seems to be very much unsupported in the world. But when you're made a ward of court, then your decision-making autonomy in relation to other completely unrelated and even minor matters is taken from you. I might give you the example of a woman that I acted for when I was in practice. She had some learning difficulties. She had some history of personality disorder, but was living a pretty independent life. When she was made a ward of court, when she was awarded a large amount of compensation in the hundreds of thousands, she would have readily agreed that she needed support around managing that money. But as she pointed out to me, why was she suddenly no longer able to decide to apply for a passport, to travel overseas with her family, to give even small amounts of money to her grandchildren? And as she said to me once, why is the president of the High Court, who has never met me, deciding whether or not I'm to have a colonoscopy next Tuesday? She knew what the procedure involved. She'd had it before. She was well placed to consent to it again, but because she was a ward of court, she couldn't. It was the president of the High Court's job to consent for her. So there's a big move away from that kind of all-encompassing finding when we think about capacity in a time-specific and issue-specific way. Another notable thing about how capacity is dealt with under this Act is that there isn't a diagnostic criteria or threshold. So our Act doesn't say that a person might lack capacity due to some impairment or defect in functioning of the mind or brain. I think that's the formula in the equivalent legislation in England and Wales. This Act is actually silent about what might be the organic reason for a person's decision-making capacity difficulties. A person might have an acquired brain injury, but it doesn't actually matter unless it's impacting on decision-making, and in this way, so that a person lacks capacity if unable to understand the information relevant to making a decision, to retain that information for long enough to make a voluntary choice, weigh up and use that information and communicate a decision. And that's communicate with appropriate assistance if necessary. A person may require particular modes of communication, sign language, assistive technology, speech and language therapy interventions, or whatever it might be. The fact that they require those particular tools for communication is no indicator of a lack of capacity, and those tools for communication should be made available. Now, I refer to this as the statutory functional assessment of capacity. And by the word statutory, what I'm saying is that the Act is putting into black letter law what is, in fact, already the law, because this standard, this approach, was already set out in a High Court case as long ago as 2008. That was a case which concerned a woman's capacity to consent or not to a blood transfusion. It had been administered when she'd suffered a postpartum hemorrhage, and then this all got litigated afterwards. She was saying that she had capacity to refuse that, and that refusal should have been accepted. Looking at the facts, the court concluded that this woman did not have capacity. She didn't understand the information relevant to making the decision. The thing that's memorable about that case is that she apparently had said, it was in her notes, that if she was given Coca-Cola and tomatoes, it would have the same good effects as a blood transfusion. So this was taken as evidence that she didn't understand the information relevant to making that decision. I acted in a case where the opposite finding was made. I was acting for a man who was in prison and had embarked on a hunger strike. And he was found to understand exactly what was involved in pursuing that hunger strike to its conclusion. It would have struck most people that there was nothing rational about his decision to do so, but he understood what it would mean to die as a result of his hunger strike. And there were some, very emotional discussions with him about that in the judge's chambers, but her conclusion was that he did understand the decision that he was making, that he had arrived at that in a capacitous, that is a real word, in a capacitous way. So Fitzpatrick is the case about the blood transfusion. This is with us already, and it's already in policy. You'll see it, for example, in the HSE National Consent Policy, or indeed in Irish Medical Council guidelines. The functional assessment has been with us for some time. Just a word on terminology. When I say relevant person, or RP, if I do, we're talking about the person who's at the heart of this act. Section 2 sets out a bunch of definitions. So relevant person is that person whose capacity is in question or may soon be in question, or B, they may have been found to lack capacity in relation to a particular matter. And then paragraph C acknowledges that a person might fall into both paragraphs at the same time in relation to different matters, remembering again that capacity is time specific and issue specific. It's not for all time and for all purposes. And equally, a person may not be a relevant person at all in respect of other decisions, so that my former client may well have been found to lack capacity to manage the significant sum of money, but there was no question mark at all over her capacity to apply for the passport or consent to, the routine healthcare intervention. And decision supporter, if I say that, I mean each of the below, and I'm going to come to them in turn: the decision-making assistant, co-decision maker, a decision-making representative appointed by the court, an attorney under an enduring power of attorney, or a designated healthcare representative named in an advance healthcare directive. So when I say decision supporter, I mean all of the below. It's not actually a term in the Act. We say it in the decision support service, so we don't have to say 5 things each time. And these are the guiding principles that I mentioned. So the first of these is the presumption of capacity for adults, so that an adult is presumed to have capacity to make the particular decision. And this, again, like the functional approach, is already the standard in common law. It's a rebuttable presumption, but if somebody is to be found not to have capacity, it's following that functionally applied test. Again, it's with us already. Is it always respected in practice? I suppose that can be patchy. I'm thinking of a case I was consulted about. I can think of a few actually. Yeah, I acted for a woman who had inherited a sum of money. Not very much. She was a woman living in services, and the solicitor who was handling the estate had not given her the money because she was in services and had an intellectual disability, and was applying a presumption of incapacity in effect. So eventually that got corrected, but the starting point of the legal practitioner who had never met this woman was: here is somebody with an intellectual disability, and therefore I have to look past and around her and over her before she can be given the proceeds of the estate. People must be supported to make their own decisions as far as possible. I think our Act is quite strong on this. I mentioned the name change in the Act and how it was once called the Mental Capacity Act. It's now the Assisted Decision-Making (Capacity Act). So it isn't an act which is fundamentally about assessing capacity or obtaining consent. The starting point is that people have to be supported to make their own decisions autonomously. You don't move even to assessing capacity until you have exhausted the every means to allow people to make their own decisions independently, and I think the Act is strong on that point. The next one can sometimes seem a bit challenging. An unwise decision doesn't mean that the person lacks capacity. Sometimes that's misleadingly shortened to the right to be unwise. None of us has an unlimited right to be unwise. We are all rights holders who have to exist alongside other rights holders. But what the Act is actually saying here is that the fact that a person wants to do an unwise thing doesn't mean that they lack capacity to make that decision. It might be an indicator, particularly if it seems very out of character, that perhaps further supports are required, or that capacity may need to be assessed and formal measures considered. But wanting to do that unwise thing is not conclusive of a lack of capacity. I was presenting at an event recently and somebody said, does that mean I have to let my husband buy a Ferrari? And saying, no, I don't think you've got my point. But wanting to buy the Ferrari did not mean that he lacked capacity to decide to do so. There are other arguments about why I shouldn't have one. So just I hope that point's clear. It can sometimes seem a bit challenging. The Act, I think, is strong in the next few points: minimal restriction of rights, minimally invasive measures, dignity, bodily integrity, respect for privacy, autonomy, and the right to control over your own affairs. It's important that people are permitted and encouraged to participate in interventions that concern them. All of this is informed very much by the language of the United Nations Convention on the Rights of Persons with Disabilities. That's an important international instrument which Ireland finally ratified some 4 years ago. And at Article 12 of that convention, it emphasises that people with disabilities enjoy legal capacity on an equal basis with others. And legal capacity is that entitlement to hold and to exercise rights. And the Act is the committee for that convention are particularly strong in this next point about respect for will and preferences. And the Act emphasises the importance of giving effect as far as practicable to past and present will and preferences, acting at the same time in good faith and for the benefit of the person. But what you won't see anywhere in the 15 Act is any reference to best interests, which is, I know, the established standard and certainly appears in other pieces of legislation, but the Act is very much moving away from that assessment of what is good for a person to what they want, and taking that as our starting point. So when we talk about supporting decision making, what decisions do we mean? The Act, again, thinking about Section 2, divides them broadly into two categories, so that you have property and affairs decisions, which cover everything you might think of there: owning money, owning, buying, selling, renting property, paying off debts, court proceedings if they arose. And then on the personal welfare side, which may be of more interest to this audience, again, quite broadly drawn: accommodation, education and training, social services, access to healthcare, including medical and treatment decision making, and then that really broad other matters relating to the relevant person's well-being. So this is the new support framework for those tiers, for those sorts of decisions. These are the three tiers. So the lowest and least interventionist then is the decision-making assistant. You have the co-decision maker, and that is a process of joint decision-making. And then at the top tier, there is the court-appointed decision-making representative. Across all of these tiers, there are eligibility criteria, so that a person can't step into one of these roles in relation to a person if they have, for example, certain criminal convictions, or if there are family court orders, barring orders, safety orders, that kind of thing. Or in fact, if the person is residing in services, then the owner or registered provider or an employee of those services can't become one of these things. The perception is that they would be conflicted, and all are importantly required to apply those guiding principles that we've just mentioned, including respect for will and preferences. Okay, just to take them in turn briefly, I should say this presentation in total takes about 40 minutes, allowing time for questions at the end. So the decision-making assistant, the lowest and least formal, the appointment is being made by the person. So that, for the purposes of this part of the Act, is the appointer. It's a bundle of terminology in this Act. So here they're called the appointer, but that's, again, our person whose capacity is or may shortly be in question. And they are choosing to select somebody in their life, somebody whom they know and trust, and to put together a decision-making assistance agreement. And under that agreement, then, their decision-making assistant is able to assist them to obtain relevant information about their decisions, to explain that information to them, help them to communicate their will and preferences, to assist with that person in making and expressing their decisions, and helping to ensure that decisions are implemented. But it is quite light touch, so the appointer is still making their decision. And perhaps thinking about your own practices, and I understand that you're all, mostly in patient-facing roles, you can think perhaps about how you might encounter such a person fulfilling this role, who is there to support a person who may have that decision-making capacity difficulty, but here is somebody who's going to help them understand the information and help them to communicate what they want. That isn't to say, and I will make this point, that because this new framework exists, people need to suddenly slot themselves somewhere onto the framework. If we think again about the presumption of capacity, a person is presumed capable to say, I want my mother, my spouse, my adult child here with me. and that should be respected. But here's an opportunity to formalise that, perhaps to get around concerns that might arise about the propriety of that role and what the person is really doing, and to put in place a formalised decision-making assistance agreement which can satisfy third parties that here is somebody carrying out a role as provided for under the Act. The middle tier then is the co-decision maker. So this is more formal. Again, it's the person who's deciding to make the appointment. Their capacity is or may shortly be in question, and they're choosing somebody in their life, a relative or friend, in that pre-existing relationship of trust. There's quite a bit more involved here. The functions of a co-decision maker, again, are to assist the appointer in obtaining and understanding information and helping them to communicate their will and preferences. But the effect of having a registered co-decision making agreement is that decisions then are taken jointly if they're encompassed within that agreement. If something needs to be signed, then it is signed by both of them, for example. And they have to make reasonable efforts to ensure that the decision is implemented. A lot more formality is involved at this tier. That co-decision making agreement, given its importance as a legal document, is registered with us. It comes to us with various supporting documents, including a capacity statement, a statement which says that this is somebody who has the capacity to appoint a co-decision maker, needs a co-decision maker, and with their co-decision maker is going to be able to take the relevant decisions jointly. And that could be decisions about healthcare, for example, or having treatment. The co-decision maker has a bigger job in that they have to submit reports to us and are under our supervision. So at the top tier then, there is still a route to court. It's the circuit court. The High Court largely administers the old wardship system, and the idea of it being the circuit court is that it's more accessible, cost effective, it's regional. It begins with an application to the court by a person who has a bona fide interest in the welfare of the relevant person, likely to be a family member or a friend. It could be a service provider, it might be the HSE, as happens a lot in wardship. And what you're asking the court to do then is to make a finding about the person's capacity in relation to particular matters. So again, contrasting with that finding that somebody is of unsound mind, instead you're going to court to say, here is a person who needs to make decisions about €400,000, about healthcare interventions, about the sale of the family home in order to fund long-term care, for example. What does the court say about that? Is the court going to make a finding that the person has capacity or doesn't? And then the court can either, if they make a finding that the person lacks capacity, make the decision, and it might do that if it's a once-off decision, and that might arise perhaps more often in relation to healthcare, where there's a particular isolated decision that arises, or the court can appoint a decision-making representative if a more long-term support arrangement is going to be required. In doing so, the court has to consider the person's will and preferences. The court has to apply those guiding principles as well. The court has to look at the complexity of the decision making, whether a person who's offering to step into the role will have any conflicts of interest, whether they're going to need support to step into the role of decision making representative. And if there isn't anybody in the person's life who is available, suitable and willing, then we in the DSS actually have put together a panel of decision-making representatives who are available to be nominated to the court. They would comprise legal professionals, but also healthcare professionals, people from social work background, and there's quite a range, which I think will be important when you consider the range of decisions that they may have to make on behalf of the person. Again, it's not forever. It is the decision-making representation order is limited in time and scope, and is kept under review by the court. Just a few more points then on that DMR. There are certain restrictions. They take their authority from the court order. They can't make decisions concerning life-sustaining treatment, but they could be appointed to take decisions broadly in the area of healthcare. So that it may be, for example, if you were administering a vaccine, that somebody might say, I'm the decision-making representative here and authorised to supply consent. You will want to know that they really are, and we will have a register of these arrangements that you're able to confer with, and if necessary take up a copy so that you can satisfy yourself that the person who is supplying consent is properly authorised to do so at present. The DMR, notwithstanding that they're an agent and making decisions on behalf of the person, still again has to think about their will and preferences. That doesn't go away. And they do have to report into us, keeping accounts and records and informing us about the decisions that they're taking. And we supervise them, and we look at their reports on an annual basis. And it's all capable of being brought back before the court if that isn't going well. Advanced planning, if I can move on to that, you will know that advanced planning already exists and has since 1996 under an act called the Powers of Attorney Act. There are some differences. If somebody has a 1996 EPA, then they're still fine. But if you make a new one after this act comes into force, then you're making a 2015 Act EPA. The idea of advanced planning generally is that it allows any of us to plan ahead while we have our capacity about us, and we can appoint then decision makers, an attorney who's going to be there to step in if we lose our decision-making capacity in respect of these particular decisions in the future. What is different under this act is that those attorneys come under our supervision. Capacity statements are required before an EPA is put in place and before it comes into effect. And the only interaction that we might have with a 1996 Act EPA is that we can take complaints about them as well. But if you happen to know anyone who has a 1996 Act EPA in place, then that is still a good document. Okay, the other one then, the other tool for advanced planning is the Advanced Healthcare Directive. And the Act restates the fundamental principle that treatment is predicated on consent, and treatment has a very broad definition in the Act. A person who has capacity is entitled to refuse treatment for any reason, notwithstanding that the decision might seem to be unwise, not based on sound medical principles, or may result in death. So the Advanced Healthcare Directive is made when the person has capacity, and it enables the person to be treated according to their will and preferences. It allows the healthcare professionals and indeed the people in the person's life to know about their treatment choices. The directive maker, that's the person making their Advanced Healthcare Directive, may appoint somebody called a designated healthcare representative. So this is our fifth decision supporter. Somebody who is named in their Advanced Healthcare Directive, who will act as their agent, if you like, who is able to make sure that others know about and respect the Advanced Healthcare Directive. And a refusal of treatment is as effective as if it's being made contemporaneously. So that if I set out in my Advanced Healthcare Directive that there are measures which I'm not going to want, if I don't have the capacity to refuse them in the present tense, then that refusal contained in my AHD is as effective and as binding as if I'm able to say it in the here and now. That can't include life-sustaining that can extend to life-sustaining treatment, but it can't include a refusal of basic care, so that you can't validly say in an Advanced Healthcare Directive, if I lose my capacity in future, I do not want ordinary oral hydration or nutrition or warmth or hygiene measures, for example. If there's an ambiguity about whether the Advanced Healthcare Directive applies, whether you have called out in your Advanced Healthcare Directive the treatment which is now under consideration, then there is a route to court for the court to step in and determine applicability and also whether it's actually valid, whether it meets validity requirements in terms of being signed and witnessed, for example. There are provisions to protect healthcare professionals from civil and criminal liability if you don't know about an AHD, if you know about it but can't find it in time, for example. And the existing criminal law in relation to murder, manslaughter, assisted suicide is not affected. The Act states that also. Okay, this might be of interest. Next of kin, and what does it really mean? It doesn't mean anything, never has, when a person is alive. And this can be news to people sometimes. The fact that you are a person's spouse, partner, adult child, or the child of an adult parent who isn't able to make their decisions independently does not give you an immediate legal status to step in and make the decision for them. Outside of a legal arrangement, that has never been true, and this Act is not taking anything away in that regard. If you are a person's attorney, thinking about the here and now before this act has commenced, if you're the person's attorney, or if you're their committee, as it's called, for some day-to-day business where the person is a ward of court, then you may have that authority. Other than that, that isn't the case. We're not helped by the fact that next of kin shows up very often on official documentation. I happen to know this from personal experience lately, where my husband broke his arm 2 months ago, and when he was going into surgery, he was asked who his next of kin was. And I said to him, I hope you told him that that doesn't mean anything. And he said, I absolutely did not. I had a very sore arm at the time. What they really meant, I suppose, was who's the emergency contact person, who's the person that we can talk to if they ring up and say, is he out of surgery yet? But that's quite different from saying that I was going to be able to decide what was to happen next. Not to say that the next of kin isn't a person of influence and not there to be consulted, but that's with a view to understanding what the person wants, not because you're saying you now get to decide to the next of kin. So we often say with this act, it's not taking anything away that you had, and in fact, it's providing an opportunity where it might be appropriate for you to step into a formally recognised role. And again, even if you didn't say if somebody else is the decision-making representative, that decision-making representative is still supposed to confer with the person closest to the relevant person, again, to find out what they want, not because you're going to defer to the spouse, the partner, or the adult child as a decision maker. I encountered this again in practice where I was consulted about a man with a disability who needed root canal. And the dentist was, in all good faith and conscience, trying to track down all of his surviving siblings, his parents, who had always, in quotes, decided were now deceased. And she was trying to find all of his siblings. He was from a big family. She was trying to find the one that nobody had heard of from 10 years so that they could all sign off on his root canal, which was missing the point that they weren't authorised to do so, and also missing the point that here was somebody who was well placed to consent all by himself, but she wasn't asking him to do so. Got there in the end. I mentioned the results of surveys here recently conducted, which show quite how widespread that belief is, including that belief that the next of kin is able to make healthcare decisions and consent to treatment. Almost 60% of people thought that was true. The Decision Support Service. So we are established under the Act. We were going to be called the Office of Public Guardian, and that name change was made, I think, to call out again that this is an Act and we are a service which is primarily about supporting people to make their own decisions independently and putting in place supports where supports are required. Whereas guardianship, I suppose, had those connotations of deciding for people and somewhat infantilizing them. We have a job to promote awareness and confidence in the new framework, to provide information and guidance to organisations and bodies. We reach out across really diverse bodies to do that. I think we spoke recently to the Rape Crisis Centre and the Central Bank and the Guards and a disability service provider in the same week. This is really the reach of this Act. Those registers that I mentioned will be searchable, and there is going to be a regulation that shows how that's to be managed. So the person with a legitimate interest is able to get into the register when you need to satisfy yourself that somebody is properly acting in scope of one of these formal arrangements, or members of bodies or classes of persons will be able to do that. Those regulations are just being fine-tuned at the moment. Of another meeting about them next week. They belong to our department. We supervise those support arrangements, as I've mentioned. We also have a complaints and investigations function. We have a duty to support organisational change to promote the exercise of capacity. I've mentioned our panels. In addition to that panel of decision-making representatives, we will have panels of special visitors and general visitors who have expertise able to help us with our supervisory and complaints and investigations functions. I'll mention the codes of practice briefly, and we have a function as the central authority under the Hague Convention. That's an international document which governs support arrangements where there's a kind of cross-border aspect. So if somebody showed up here who had a formal arrangement registered in another convention country, or if somebody from here goes to another convention country. Okay, complaints investigations, the Act does have safeguards. So we are a regulator. We're a regulator of the new support framework, and we can take complaints, for example, that a supporter is acting outside of scope or is unsuitable as defined by the Act, or we think that fraud or coercion or undue influence has been brought to bear to encourage somebody to enter into one of these arrangements, or if somebody is breaching those guiding principles. And then we have various powers which would be familiar to any regulatory body in terms of taking up evidence, escalating to court if need be, or indeed seeking to resolve complaints informally. Those are complaints about the decision support arrangements and about people who've stepped into that role. We're not there to take complaints about other professionals or services. We're not the regulator of anybody else. So if somebody were to come to us and say, I went into the pharmacy with my co-decision maker in order to, consent to a measure that the pharmacy was going to carry out for me, and the pharmacy just was not acknowledging that I have a co-decision maker at all, I think we'd get involved if asked to ensure that there's a good understanding of what this Act means and what this specific arrangement was for. But that doesn't mean we're proceeding in any way against the professional concerned. We've enough to do, and you've got your own regulators. We don't make decisions for people. We don't directly appoint decision supporters to people. We don't happily have a function to manage people's money or property. Some of these are the roles of public guardian offices in other jurisdictions. In many ways, what we do is broader than in other jurisdictions, but we aren't the decision maker of last resort. And we can only regulate and supervise arrangements that come to us. When you think about it, there's that high level figure of 200,000 people. There only are 2,200 wards of court currently. And actually, enduring powers of attorney have had quite limited take up over the last 25 years. Something like only 6% of the population have them. So very evidently, decision making is managed in some other way at the moment. And we simply don't know about and aren't on notice of those arrangements. Is all of that happening in a way which is consistent with the Act, with the UN Convention, with the guiding principles under this Act? I think it's timely to consider how all of that is being managed, and whether is this a person who would benefit from the formal framework. But unless people come in under the formal framework, we literally don't know about them. We encounter this a bit with family carers who have this apprehension that we're going to start policing their lives. We just don't know about things other than what the Act provides. Codes of practice. I mentioned that this is one of the decision support services functions. Draft codes of practice were prepared by the National Disability Authority and an HSE working group. There were 14 draft codes in total that came to us, including an overall number 1 code, that, as we call it, about supporting decision making and the assessment of capacity. There is guidance for each of those 5 decision supporters, and one particularly aimed at healthcare. And then a specific one around advanced healthcare directives as well. A public consultation was conducted between November of last year, February of this year. We're really pleased by the scale of response. So we were able to take that really good feedback from people on the ground, what they thought would work, what wouldn't work, and incorporate those responses as appropriate into further drafts, which are now sitting with the ministers for approval prior to commencement. And the status of any code is that a person concerned shall have regard to a code of practice when performing any function under the Act, in respect of which the code provides guidance. So breaching a code that we have published is not of itself a civil, or it doesn't give rise to civil or criminal liability, but it's something which is admissible in other contexts. So for example, if a person was in front of their regulator, if the complaint concerned something that amounted to a breach of this code, then that code could be considered by the regulator. And where are we on the very long journey to commencement? Well, as I said, I think at the start, our job is to set up the DSS. We don't own the Act. We are established under the Act with good level of engagement with our department, and that's now Children, Equality, Disability, Integration and Youth. And we've been working to a project plan over the last 2 years now to be ready this year. Our design principles are very much for that person-centred approach. We are an outward-facing and accessible service. We're located, I should say, within the Mental Health Commission. We were going to be in the court service. Again, one of those changes that was made as the Act made its way along. but we're now in the Mental Health Commission, but have obviously completely different functions from the rest of the Commission, but it's been a good home. Our approach, the intention is that it's digital first, so that an engagement with the DSS in whatever way you need to do that would primarily be across a digital platform. That's been broadly well received by the focus groups that we have worked with and our own stakeholder forum. But it won't work for everybody. We appreciate that, so there will be workarounds and alternatives to the digital process. Our communication is ongoing all the time, and our public awareness campaign too, that will kick off in earnest as we are around the commencement point, which should be just a couple of months away. And we're developing tools and templates all the time and engaging directly with our stakeholders, as I say. One of the key external dependencies has been the Assisted Decision-Making Capacity Amendment Bill. Now, I won't exhaust you with law, but the Act, before it even gets commenced in full, is being amended in bits and pieces. That's not to say that anything I've just said over the last 40 minutes is being dismantled at all. It's not. What is core to the Act is staying the same. It is a long and quite complex bill, but it deals largely with fairly procedural and technical business. And that is back in front of the Seanad tomorrow. So we'll see how that goes. It needs to complete that journey over the next number of weeks. But that's been the key piece of the jigsaw that needed to be finished in order to allow the Act as amended to be commenced and for the Decision Support Service to open its doors. So this is my attempt at things that might be relevant to this audience in preparation for commencement. We do see healthcare and social care as being the sector that may well be most impacted by the Act and the functions of the Decision Support Service. So with that in mind, you may wish to familiarise yourself with the codes of practice that I mentioned. I think there is a point in adapting to the idea of this functional approach to capacity is established already. I have no doubt that it's something which you are doing, perhaps without even, calling it the functional assessment of capacity. It was interesting to see, actually, with the vaccine rollout, it struck me a lot of people who were first in the queue for the vaccine may well have had a question mark about their capacity when you think about those particular populations who were first in line. And if you were to look at the particular statutory instrument that managed the whole vaccine rollout, it dealt with a lot of practical stuff about, how to dispense and get the vaccine out there, and a lot of those regulatory pieces. But it also looked at consent. And the statutory instrument said, if you can't formally get consent, then record will and preferences, which I thought was interesting. It was the first time, I think, that will and preferences as a thing were mentioned outside of the 15 Act itself. And certainly the President of the High Court said, don't think of taking these people into wardship in order to administer a vaccine. But I think that next of kin piece might have arisen there as well, where certainly one heard anecdotally of adult children of nursing home residents saying, no, my mother won't be having that. To be told you actually don't get to decide strikes me from, no doubt those conversations had to be had, but given that we heard relatively little about that, I think those conversations manifestly were managed well. I think that in your profession, you might anticipate interactions with these new decision supporters who have stepped into these formal roles. There will be that practical question about being able to access our registers if that arises for you. And it may be that it's a pharmacist who becomes aware of a problem in a decision support arrangement where somebody who is meant to be perhaps only the decision-making assistant is trying to decide for a person. And also, I've made the point that we don't own or regulate outside of our own remit. So I think it's, and I do say this across many sectors, what are your own regulators doing? What are the people who train and employ you doing to establish guidelines around best practice? Because we don't attempt to tell healthcare professionals how they need to manage the day-to-day. What we say is, here is an act, here is a code written under an act, and then it's for each sector to take that and incorporate into best practice and standard setting. How can I find out more? I'll say in just on the very last slide, but again, and I won't read these out in full, but this is what kind of keeps us straight and reminds us of what we're for. These are quotes taken from contributors to a book to which the DSS contributed, published last year, on personal and professional responses to the Act. So I think these speak about the enthusiasm of certain stakeholders who have been waiting for this Act for a long time, and their expectations of it, with one contributor referring to this Act as their act of emancipation. So no pressure at all to make that happen. And very lastly, then, you can find out more on our website, Decision Support Service. .ie. If you're not aware of it, there's also really good work done by the HSE Human Rights and Equality Office, and you'll find them on our, let me get this right now, assistedDecisionmaking.ie is their website, but they have really good content up there as well, webinars, and if any of you have access to HSE land, I'm not sure how broad that is, there's really good recorded content there as well. So yeah, feel free to address questions to us via the website, but I think I've left myself 10 or 15 minutes to take them in the here and now, and happy to do so. So thank you very much for your attention.
That's lovely, Áine. Thank you so much. I'm going to pause or stop the recording now, and we will move on to the question and answer part